Well, welcome to all. My name is Jose Alvarez. I'm the faculty director of the US Asia Law Institute. Welcome to our speaker series. I will shortly introduce our speakers for today, but I just want to mention next week's program is China's bid to join the Comprehensive and Progressive Trans-Pacific Partnership, the view from Japan and the United States. And we have two experts on this, both of whom participated in a recent book published here at NYU called Mega Regulation Contested Global Economic Ordering After the TPP. And our guest will be the professor of government at Harvard University, Christina Davis, and her interlocutor is Dr. David Malone, the rector of the UN University and Undersecretary General of the UN. That program is next Wednesday, February 16th, from 9 to 10 a.m. It's part of our US-Japan short take series, so it's only 1 hour commitment, and that is Eastern Standard Time. So today, I'm very happy to welcome two sterling experts in investment law, among other things, and they have written a book that is not yet out. So this is not even fresh out of the presses. It's not even out. And I've been very privileged to see an advance copy. It's really quite a book. It's called Investment Treaties and the Rule of Law Promise, the Internalization of International Commitments in Asia. It will come out hopefully by the end of this year, perhaps even as early as the fall, by Cambridge University Press. We'll obviously get a glimmer of the book in today's presentation. First, we'll hear from Professor Calamita, who's the head of the Investment Law and Policy Program at the Center for International Law at the National University of Singapore, NUS. He's also a research associate professor there. He previously was director of the Investment Treaty Forum at the British Institute of International and Comparative Law, and has held positions at the law faculties of the University of Oxford, University of Birmingham. He also is a practitioner, as is our other speaker today. In the case of Professor Calamita, he served in the office of the legal advisor of the US State Department and also in the UN Office of Legal Affairs in the UNCENTRAL Secretariat. He's on the board of editors of the Yearbook of International Investment Law and Policy. And that's just a short bio. And now we also have Dr. Berman is head of the Global Health Law and Governance Program and Senior Research Fellow at the National University of Singapore and the Center for International Law there. She teaches there as well. She focuses on global regulation and governance, global health law, international investment law, and international trade law. She is the co-chair of the American Society of International Law's International Organizations Interest Group and an executive board member of Tradelab, a global network of international economic law clinics. She's also a member of the OECD Partnership for Effective International Rulemaking by International Organizations, which is an academic advisory group. I understand that Professor Calamita will head up, and I think he has a PowerPoint that they both will share. On to you.
Thank you very much, Professor Alvarez. It's really great to be with you and to have this opportunity to talk about our work and to talk about our book coming out later this year with Cambridge University Press. Our book concerns the way in which states internalize or take into account their international investment treaty commitments in government decision-making. And if we can have the next slide, please. To talk about this, we need to have a bit of background, particularly for those in our audience who may not be familiar with investment treaties or may not work with them all the time. Under investment treaties, states grant substantive rights, substantive protections to investors, and grant them access to international arbitration in order to vindicate those rights. And states do this, in effect, as part of a grand bargain, an exchange, if you like, for the promise that by doing so, they will attract more foreign direct investment into their economies. And it's been asserted that these treaties will thereby lead to improvements in governance and improvements in the rule of law in the host state. And the idea is, or it's been posited at least, that these improvements will inure not only to the foreign investors themselves, but that they will affect the entire system of governance in the host state for all. And this idea, this last idea, is the so-called rule of law spillover, the idea that by implementing or internalizing their investment treaty commitments, there will be benefits not just for foreign investors, but for everyone in the host state. Next slide, please. So this rule of law promise, just to unpack it a little bit more, the idea behind it is that because states face the threat of liability and arbitration under their investment treaty commitments, they will thereby be incentivized to produce better governance and to promote the rule of law in their host states. And this is a quote from Roberto Shandi from the World Bank, I think really setting out the premise very clearly that these treaties serve as a deterrence mechanism against short-term policy reversals, and they thereby assist governments, developing countries in particular, in promoting greater effectiveness of the rule of law at the domestic level. And now this is a view that's been put forward not only by Roberto Shandi, not only by the World Bank, but also by prominent academics in the field, such as Stefan Schill and the late Rudolf Dolzer. So moving on to the next slide, please. So this idea that investment treaties will have an incentivizing effect, will effectively act as a carrot and a stick, and will thereby bring about change in governance and improve the rule of law, rests on a number of assumptions, obviously. The first is that the idea is that the state is somehow a unitary actor, that the state is a preference maximizing rational actor, so that indeed states are truly weighing up costs and benefits in the regulatory decisions that they take with respect to investors, and that they are choosing to comply or not to comply based upon that calculus. It also is premised upon the idea that the treatment of foreign investors will have either a deliberate or incidental spillover effect, so that if states make reforms to treat their investors in accordance with their international commitments, as I said, this will somehow inure to the benefit not just of the foreign investors, but to participants in the host state's society as a whole. The next slide, please. Now, thinking about the rule of law promise, this rule of law thesis, there are a number of reasons for doubt, and these are reasons which prompted us to enter into this study and to look more closely at this issue. And the first, perhaps most clearly, is that none of the statements advancing this idea of a rule of law spillover or of this disciplining effect have actually been based on any empirical evidence with respect to the way in which states manage their investment treaty commitments or the way in which they make regulatory decisions and how they take or do not take international law into account. So the assumptions there are, in a sense, commonsensical, but they haven't been supported by empirical data. The second is that we know, as a more basic matter, from research, that states are not unitary actors, of course. States are very diverse actors made up of many working parts, and the black box of the state decision-making process is one that's increasingly recognized as an important factor in understanding the way in which states are making their decisions, even if we don't necessarily understand what's always going on in the black box. Lastly, we also know that resources are limited in many developing states, and governance capacity is a constant issue in those states. So for us, there was a fair amount of reason to wonder whether or not looking at this rule of law promise, this rule of law thesis, if one actually looked closely at individual states and tried to understand closely what was going on in those states, we would find evidence to support this thesis at all. Next slide, please. So our book looks at two questions. Do governments internalize investment treaty obligations in their decision-making processes? And second, if they do or if they don't, what factors affect whether governments internalize those commitments into their decision-making process? And we do this, we take the position that in order for an investment treaty to have any disciplining effect, it's essential that those to whom the obligations are addressed are actually aware of those obligations. So in other words, we couldn't have, or we would not expect to find any kind of rule of law spillover with respect to investment treaties and their effects, if it turned out that governments weren't actually taking these treaties into account in their decision-making. And so that brought us to the formulation of the study. How would we go about dealing with these, addressing these questions? And next slide, please. So what we decided to do was to adopt a mixed method, qualitative empirical approach, focusing on specific countries and focusing on the way in which decisions are made within those countries. We looked at Asia in part because we are a center based in Asia with a focus on Asian affairs. We chose 8 countries, 2 of which are developed economies, South Korea and Singapore, but the rest of which are developing economies, although of very different profiles. But developing economies were of particular interest to us, as it's their governance in particular, which investment treaties are often said to improve. And we chose very carefully the authors with whom we worked for each country, trying to find authors who had detailed knowledge and familiarity with the countries and had access to the persons in government making decisions so that we could gather firsthand interview evidence from them. Because we weren't interested only with what the way in which decisions are made on paper, but the way in which those decisions are being made in reality. Next slide, please. Now, the focus of our inquiry was primarily, but not exclusively, on executive branch decision-making, on administrative decision-making. And the reason for that is simply that administrative decision-making accounts for the lion's share of claims that states face. A very interesting study a number of years ago now by Zoe Williams, looking at the sources of investment treaty disputes and finding that 61% of them are triggered primarily by administrative measures from the executive branch. Now, as I say, that was the primary focus, but not the exclusive one. And indeed, in the case studies, we also looked at legislative decision-making, although again, we found much less, there are far fewer claims that result from legislative decision-making than from administrative measures. So the next slide, please. So the relevance of our study, just at the outset, is that it helps us to understand more and better about the way in which states take international commitments into account. And it's looking really at a public administration level, the way in which bureaucratic decision-making is made. We're looking really at the way in which states take international law into account in elective situations, which is to say, in which international law has a bearing upon the decision, but is not seen as a necessary part of the decision. It's not a direct implementation of an obligation in an international treaty through domestic law, but it's rather the implication of the international commitment on a ordinary regulatory or other type of administrative decision. Next, please. Now, this is also relevant very much so to policy and in terms of the challenges that states face on the day-to-day level. The challenges that are faced by entering into treaties which are pervasive in the scope of their obligations, which are under a regime where even if the state is not a unitary actor, in fact, international law treats it as one, as a matter of state responsibility, and in which, far from the way in which the rule of law thesis suggests, the manner in which decisions are made in the state are often highly decentralized and therefore not necessarily reflective of any particular universal will of the state. So to the next slide, please, and on to the framework that we've used to develop the study and to tackle these questions. So in order to assess the internalization, we developed an analytical framework which is designed to operationalize this idea of internalization. In other words, what would be the indicators that we would expect to find looking to see whether or not the states are taking investment treaties into account in their decision-making? And we developed a typology into 3 categories of measures that we would expect to find. The first are informational, and these are measures which are designed to inform and educate the bureaucracy ex ante, so prior to decisions having been made. The idea perhaps of government training courses, government handbooks, and so forth, designed to diffuse information about investment treaty commitments throughout government. Second category, monitoring measures. And these are mechanisms by which decisions might be screened for consistency with international obligations. For example, submitting a proposed regulation to the Attorney General's office for review for its compliance or the implications of international law on it. And the third then is remedial. And these are processes which are designed to either correct or defend the state's compliance with its international obligations once the decision's been made. So has the state enacted mechanisms, created mechanisms, which are designed to deal in an ex post way with its decisions and to correct those decisions where appropriate in advance of the investor bringing a formal claim under the treaty. So here what we had in mind were things like ombudsperson mechanisms that would be in place to give the investor a point of contact within government to bring its grievances and attempt to have those grievances adjusted before they would ripen into a formal dispute. So with these three categories of typology, of processes and measures of internalization, we also then noted a few cross-cutting characteristics that we imagined we might find in our case studies. And the next slide illustrates those. And the first is considering whether or not the mechanism, any given mechanism that we might come upon, was specifically tailored or addressed to investment treaty commitments as such. Had it been created for that purpose? Or was it a more general mechanism of, for example, information diffusion within government that had been repurposed, co-opted, or otherwise had investment treaty commitments brought within its umbrella? The second was to consider the nature of the process and whether or not it was an ad hoc process or an ad hoc measure, or whether it was one that was consistent and fixed over time. For example, does the state do regular trainings as a matter of course for its bureaucrats, or does it do them sporadically in an ad hoc way, depending upon whatever factors may influence it? The third is whether or not we would find measures which are formal or informal. The idea here again being that formal, legally binding measures might be enacted as a presidential decree or a regulation with respect to, for example, the way in which line ministries would be required to give notice to central authorities about a prospective grievance or dispute coming down the pipe. In some states, we might see that as being a formalized regulation. In other states, the process might be informal. It might be through relationships. It might be through a kind of a culture of cooperation and a culture of advice. And then finally, examining these measures, are they is the measure simply one which exists on paper, or does it indeed actually happen in reality? And this is a big issue that we found, as Ayelet will talk about in a bit, where we have situations in which a policy or a process for internalization is set out in policy. It looks good, but there's an open question as to whether or not it's actually being implemented or being used in practice. So let me turn things over there to Ayelet to talk about the findings of the study.
Thank you. Great, Jansen. So yeah, so after Jansen has now kind of presented the main theory that we're trying to examine and the analytical framework, what I want to do now is in the not much time that we have, but kind of give you an overview of some of our main findings. So what we essentially did at this stage was really take our analytical framework of internalization measures and applied it to the case studies which were carried out by our fantastic collaborators in Asia. I think if we want to make one big takeaway from the study, then the general takeaway is really that the impact of investment treaties on internalization has been minimal. We find very little evidence on internalization. That being said, when we were looking at the data, it became quite clear that we need to distinguish when looking at the question of internalization between two time periods. So between the time period where a state has concluded an investment treaty but has not had any ISDS case, and the time period after there had been an ISDS case, because we did see, and I'll talk about that shortly, that the claim in itself did trigger some internalization measures. So I'll talk about these two different time periods. And Jessica, if you could please move to the next slide. So here, regarding this first time period after treaty adoption and before ISDS, I think, again, as I mentioned, really there was very limited, and looking at all of our case studies, kind of the general takeaways that there were very limited internalization measures, whether informational monitoring or remedial mechanisms. I think that's especially true of low-income countries, low and middle-income countries. There was some exception when we look at the high-income countries. So if we look at the two high-income countries that we were looking at were Korea and Singapore. And if you look at Korea, for example, there we see that especially after the conclusion of their free trade agreement with the United States in 2010, there we see that they adopted what we would call informational measures. So they adopted kind of a handbook, which was targeted at government officials with information about investment treaties. And they also had training programs for government officials. So we did find this evidence of informational measures. Singapore was almost, I'd say, an outlier, because we see from the very beginning, the case study on Singapore really shows that irrespective of any claims, there is quite an abundance of informational and monitoring mechanisms within the state. Many of them are informal in that they're not necessarily written down in legal procedures, but there is such the bureaucratic culture or structure is such that there's so much coordination and collaboration within the bureaucracy that these things are discussed and reviewed as a regular process of decision making. And of course, also there's a high political commitment to international law within the government, and I'll say about that something shortly. So I think really, again, before ICS claims, we see that most countries don't have any kind of internalization measures, and most of the information on investment treaties is very much focused, just one more point on the previous slide, within the central nodes of government. So within those ministries that have concluded, that have negotiated the investment treaties, depending on the country, this could be the Ministry of Justice, this could be the Ministry of Industry or Trade, or the Ministry of Foreign Affairs, could be some of them, again, depending on the country. But most of the information is really focused, is centralized there, and is not being diffused to other parts of government. Next slide, please. Yeah, and then we have, most of the countries have been, with the exception of Singapore, where there is no public known case of a claim. All of the countries we looked at had ISDS cases, some more, some less. And so the question is, what kind of impact has that have in internalization? And I think what we see across the board is that it has really increased political salience. So really coming out of all of our case studies, we see that suddenly countries that had no debate really about investment treaties, they are now debating and talking about investment treaties, especially in parliament. So we see that really nicely. I mean, obviously we don't have time, but I'll give you one example. So for instance, in India, Prabhasha Ranjan, he wrote the case study there, and he really shows that until the 2011 white industry case, there aren't any parliamentary debates on investment treaties. And from that point on, we see all kinds of questions and debates going on. And we see that also in Korea, in Indonesia, and Thailand. So in terms of political salience, that has definitely increased. So we could say, there's much more increased awareness to investment treaties following ISDS claims. Also more public debate in some of the countries. But then, the rule of law thesis would say, okay, now that there is more salience on this topic, we would expect there also to be more internalization. And that's where I think that outcome has not really happened as one would wish. So what we mostly found is that in quite a lot of countries, we do see the adoption of informational measures. So again, we see in India, and Indonesia, and Vietnam, and Korea, we see that suddenly they have more training programs. In Korea, they revised their handbook. So they set out a second handbook on investment treaties. So there is this effort to diffuse information within the government about investment treaties. So on the one hand, that's great. We see this movement. But if you look at it a little bit closer, you actually see that in a way, it's quite disappointing, because first, it's still very limited within the central government. And also many of these reforms are quite ad hoc. They haven't been institutionalized. They're not part of some legal or institutional process. So they're quite sporadic. Very often, they're kind of dependent on funding from external donors, capacity building by the World Bank or UNCTAD. And so they're really not institutionalized in any way or form. But I'd say those are kind of the main kind of measures that we've seen adopted after ISDS claims. Monitoring measures, again, haven't really found too much. There were some efforts that really didn't bear any fruit in India. Again, I don't really want to get into it now. We can maybe get into this in the question and answer session. In remedial measures, again, I think we don't really see any adoption of remedial measures, with one exception. In Vietnam, we do see an adoption of certain monitoring and remedial measures. And that was kind of the main exception that we found. In addition, we did see that some countries like Korea and Myanmar had certain remedial mechanisms at the ombudsman. I think that Jansen mentioned previously, Korea has an ombudsman, which it actually had set up as part of investment facilitation reforms. So kind of reforms around streamlining kind of the domestic administration, which weren't directly related to investment treaties. So it wasn't in response to investment treaty claims, but there are now kind of debates happening about should we repurpose these remedial mechanisms. So overall, I think, as I said, the main focus has been really on informational measures. That's where we see the reforms. Another thing that came out on this issue, which we hadn't actually included in our analytical framework, but really which we discovered as we did the research, is that not many, but we found three cases. It was in Thailand, Indonesia, and India and Indonesia, that again, the rule of law thesis essentially says, in response to a risk, in response to the risk to claims, countries will actually reform their internal processes. But we see that some of the countries have actually moved towards trying to change their investment treaty obligations. As I see time is short, I'll try to move on to other issues. And again, maybe there's something we can come back to in the question and answer session. If you could move to the other slide, please. Okay. So one of the things we try to do is really try to answer what factors impact internalization. And within our framework in the beginning, building on the policy literature, legal literature, law and development literature, we try to identify factors which could impact internalization. And we framed it as factors at the public administration level, at the national level, and at the international level. Jessica, if you could please move to the next slide. And then through that framework, we were looking at the case studies and try to understand which factors actually impacted internalization. And the ones here listed on the slide are really kind of the main factors which we found to impact internalization. I'll go through them very fast, and then maybe we can talk about them. So as I mentioned before, ISDS claims have been kind of one of the main triggers for internalization measures. Central government fragmentation, so the extent to which a government is unified or works as a whole of government, whereas as opposed to fragmented, and then information and monitoring is not as effective. Decentralized governance, we saw that in some countries where the federal states or very large states where the central and the local and regional governments are quite detached, that has also caused a gap which undermines internalization. Another interesting point, I think, has been the role of Parliament, because in investment treaties, in all of the case studies we've looked at, are actually not ratified by Parliament, and also because they don't have any positive obligations, they do not get adopted into national law. And so they actually get adopted kind of under the radar of Parliament. And our sense was that this had an impact on internalization as well. Political commitment to international law, as I mentioned before, I think that's had a significant impact on the approach of bureaucracies and governments to internalization. And the last 2 points are really bureaucratic organization and culture. We saw that some of the countries had a lot of rotation of their government officials. And so with that, the institutional knowledge actually got lost. And that also undermined internalization. And then finally, this won't surprise you, of course, the whole matter of regulatory capacity and resources. To have information about investment treaties, to monitor, you need knowledge, capacity, human resources, funding. And so countries that don't have a lot of that, obviously that also undermines their internalization. If we could move on to the next slide, please. I think, yeah. So really the final conclusion coming out of this is that internalization overall has been very, very weak. And since, the way we've structured our analysis is to infer whether the rule of law, if there is any kind of spillover. So seeing that there's actually investment treaties are not really taken into account in the decision-making process, we infer that there isn't some kind of general rule of law spillover. That being said, we did find some cases of improvements, but they were very much focused on improvements for investors. So generally, it's certainly not general rule of law thesis, but very specific investor-related improvements that came out of the ISDS claims.
So your book is quite pessimistic on the rule of law promise. It also, along the way, cites many studies that are dubious on the other promise, which is that entering into these treaties will increase FDI flows. So if the two main rationales for concluding international investment agreements are not quite satisfied, why conclude them at all? Isn't the bottom line that you're suggesting that these treaties are not worth the paper they're written on? Either one of you.
I don't think we go that far. With respect to the studies that have looked at whether or not investment treaties attract greater amounts of FDI, we take the view that it's a mixed literature on that subject, and it's certainly one on which there's no consensus, I think, with respect to whether they do or they do not. There are studies which go both ways. What is clear is that in the face of those studies and in the face of their own knowledge on the ground, states continue to think that they are important for their overall package of attracting FDI into the country. Now, there are ways that we can talk about in which these treaties may be, perhaps the beneficial effects of these treaties for governance might be improved. But we're focusing on that. I mean, we're focusing on the internalization aspect. So I wouldn't take this study as being a final nail in the coffin for the argument in favor of investment treaties.
Professor Berman, do you want to add anything to that?
Sorry, yeah, I think it's a very legitimate question. I mean, the way I see it, the main focus of investment treaties, the main goal is really to increase investments to the country. That's a question we have not looked at. And I think it's a very legitimate question to ask those scholars which are doing that kind of work. I feel that, the rule of law thesis was kind of a secondary cell of investment treaties. And
so I guess, sorry to interrupt, I guess my question is premised on if states, at least many of the ones, are not internalizing the treaties, then the obvious question is, if you don't actually do what the treaties compel you to do, how do they affect investment flows? Or is it just a symbol? We're open for business. And if that's the case, why not just enter into political commitment that says that?
I don't think that what we see here is a problem of internalization. I haven't understood that as a not wanting to comply. And I think that's a distinction we make in the beginning of the book. There's a distinction between internalization and compliance. The question of compliance is one where states kind of have a battle of the norms. Whether they're bound to is one aspect of it, but they might have other political considerations. So a state might very well want to comply, but hasn't really figured out how to internalize
in fact, and that's important because I think your book makes that distinction, but I wasn't clear that your presentation actually distinguished your version of internalization versus compliance. And I would add, there's a third category that compliance people have asked, which is effectiveness, right? That's the third thing. It could be that you're in full compliance, but these treaties are just not simply designed to give effect to, say, investment flows. So, there's an initiative to have investment facilitation, agreements, either in addition to IIAs or as part of the WTO, where you're committed to have facilitation of various kinds. And that's generally not something that these treaties do. But I guess the other question that comes out is, given what you see in terms of a general pessimistic conclusion, with some exceptions that we can talk about, are there ways that come out of your study that would improve the rule of law promise? And one thing that struck me, both Professor Calamita and I worked at the US State Department. At the time that I was doing these bilateral investment treaties, the US claimed that it would look in advance at the country's laws to see if the country was ready to sign a bilateral investment treaty, because it didn't want to enter into a treaty in which the only result was a bunch of investment claims. So is it important, in your view, to make sure that the countries that enter this agreements are already in compliance, and maybe it should be built into the treaty in a way that says implementing legislation is required? I'm just looking for takeaways to the folks who negotiate these things. What would you recommend as something that would help internalization?
I think the first thing that comes out of our study is the reminder that these treaties are not self-implementing. They require positive action by the states which adopt them in order for them to be internalized. They require political commitment from, at a policy level, that these treaties are important and that they have implications for the way in which the state is going to do business, the way in which it's going to govern. The other is that capacity. And as you say, most of these treaties don't address the capacity side of things at all. That's not to say that some don't. And I think it's perhaps something we see more and more particularly in FTAs, where they're more elaborate integration agreements. But what we do see is where the developed partners in an FTA may support a work program for training and helping developing members of the FTA improve the legal environment for investment, work on investment facilitation, on governance issues, and on internalization issues. And a principal example there is the ASEAN, Australia, New Zealand Free Trade Agreement, which has a rather deep work program precisely in that direction. So, I mean, these are things I think that negotiators can think about when they're entering into the treaty. Obviously, is there the political commitment to actually follow through if we sign this thing, because it can really bite. But two, are there ways that we can build into the treaty through like a work program, through capacity building training, that kind of thing?
The other thing that you mentioned, which is quite interesting, is the lack of parliamentary involvement. In the United States, unless things have changed, bilateral investment treaties have to go through the Senate, as opposed to FTAs, which involve both the House and the Senate. But in either case, they involve the US legislature. And I wonder if that's something that states need to reconsider. That is, if you want to take this seriously, especially in states that have active legislatures and democracies in particular, wouldn't it be better for these to actually go through some form of legislative or parliamentary approval?
Ayelet,
Yeah. I think, that's really something, when we went into research, we hadn't even really thought about that as a factor, but that's really something that came out. I think, as Jansen mentioned, when we were looking at countries, how they dealt with FTAs, and FTAs goes through some kind of domestic implementation. And we saw so much more debates there and much more awareness, and apparently also more internalization, though we hadn't actually looked then at FTAs. So that's, if someone's looking for another research question, please go and look at how FTAs, but there is a good sense that there was a different approach to FTAs because they went through this domestic parliamentary process. So I think that is one takeaway. And there was really the sense that, investment treaties go under the radar and then are not adopted into local laws. That being said, of course, there are other factors, within every state. Even if it were to be adopted as a local law, you have regulatory capacity, political commitment to law, and so forth, which go beyond, that you'd have to think about, develop those. But yeah, I think that's a very good point that you mentioned that might have an impact.
Well,
Just to follow up on that, if I can, the Sri Lanka example is really quite interesting, where Sri Lanka contains within its constitution a commitment that international investment agreements will be the supreme law of the land, but at a constitutional level. But then when one looks at the examples in which Sri Lanka has found itself in difficulty, obviously the legal position of the commitment is just one factor ultimately in the decision making, and there other factors like Ayelet was mentioning, capacity, political will, political expedience, and so forth.
Well, and my recollection from the days of the State Department, at least under the old NAFTA, Mexico claimed that you could actually assert the NAFTA in its courts. To me, if that were actually true, and you don't have to go to investor-state arbitration, certainly the publicity surrounding any such claims might be a factor, but I don't know if you saw any of those attempts or in any of your case studies.
No, and of course there are a variety of treaties which indicate that a claim might be brought in the domestic courts, but the usage of that has been de minimis, if any. Yeah.
Right. Now, your study is very careful about not to get into regime type and suggest that either one kind of government or another, but at various points, you do suggest that you probably would adhere to the view from liberal theorists that democracies might do better, both with respect to these treaties or with international law. And I'm a little curious about that because I've never found that intuitively true in terms of the theory, right? If you have your unitary states idea, I would think that that would mean that federal states would have more trouble, but it also would mean that a state that has to have all three branches involved and has an open civil society to get its act together might actually have more trouble complying with these treaties than, say, an authoritarian government that can pretty much dictate, yes, this is what we're going to do, and we don't have to bother with convincing our parliament, we don't have to bother with convincing civil society. But you're sort of, I guess, as I read this book, it is either not going there or it's suggesting that liberal states do better, just like Anne-Marie Slaughter always said, and I always debated her on that. So what is the answer? Does regime type matter at all?
Ayelet, you want, or?
No, you're right. I don't think we really got into that. It was very hard to decipher, actually. I think we try to go around that, with whatever that we really try to put out there the evidence we found without making up things. I think what we saw is very strong is political commitment to international law. And that could be in a democratic or not democratic state if that's within their interest, if they want to liberalize the economy and they decide that, international economic law is important for liberalization, then we do see higher levels of commitment there, which is not necessarily always bound to democracy as such. And I think, the issue of decentralized very much related to capacity in the end. Like if you're a very decentralized state, but you have capacity and, diffuse information, then that works. But if it's very big, like Indonesia, and it's quite decentralized, then it's very hard for the information to get diffused. So I don't know that we really said anything about regime type.
And I don't want to push you where you didn't go, but one thing that does come out, and by the way, I'm going to be going to questions in the box pretty soon, because we do have a commitment to end by 1:30. So be sure to put your questions in the Q&A box. One thing that comes out is that both Vietnam and Singapore may be a bit of an exception to the pessimistic conclusions. Now, those countries are pretty different from each other, particularly in terms of GDP. What explains how they're both incumbent? Because one way of taking a look at Singapore is, of course, it's very, very rich and very, very small. And therefore, that commitment and internalization is sort of predictable. But Singapore and Vietnam, how do we get there?
Well, I think, it goes back to the broader indicia of factors that we observed. And I think in both countries, what we observe quite clearly is strong political commitment to the legal environment or the environment for investment, and also significant bureaucratic capacity in each country. But Singapore is clearly an outlier given its size, particularly. And in a country like Vietnam, even with the political commitment that we see to internalizing international commitments, addressing investor concerns in the domestic law, they have a system where at the local level, they have a difficulty monitoring and guiding what local governments are doing. So they have this kind of federal problem where even if at the central government level, there's commitment and there's a dedication of resources, the constitutional structure of the country gives a fair amount of autonomy to the people's committees at the provincial level and the local level. And it's awfully hard for them still to ensure that everybody's on side, everybody's on the same page. So, I mean, even if it's just, I guess what it points out is that even with political will, even with some of the things that we find support greater internalization, there are always other factors which are coming into play. Singapore just may be the unusual one that doesn't seem to have really faced much difficulty in terms of internalization.
The other thing that comes out with your Singapore case is it's a success story overall in terms of internalization. And perhaps not incidentally, it's a success story because not many investment claims are brought against it. Isn't that a lesson that states should draw? If you want to avoid investor claims, internalize.
Yes, absolutely. Yeah. I think that's right. I mean, although there's no accounting for some claims may just arise as a result of policy decisions. I mean, we're not saying that internalization should mean that the state at each accounting, at each decision, should err on the side of its treaty commitment, but simply that they take the treaty commitment into account is, one would think, is a smart way for governments to go about things if they have the capacity to do so. But there may indeed be situations in which the state recognizes the risk of a decision based upon the existence of its commitments, but at the same time says, well, that's a risk we'll have to tolerate. We're going to take the decision to do X because we think that there's a greater good there. So, I mean, even a country like Singapore is, undoubtedly likely to face claims in the future, and they may do so with eyes wide open, though. They knew that there was a risk and they chose to take the decision anyway.
A big message that comes out, and I think both have mentioned this, is public administration, the importance of having a good government bureaucracy. And that means skill set, not just who they are, but what they do. But what is the recipe for a poor country that can't simply throw resources at its government bureaucracy? Can they still improve their bureaucracy to do better? Or is this just a matter of resources?
Should I take that? Yeah. I mean, in the end, it's a big question because as Jansen just said, I mean, internalization is it's not about compliance, it's about taking into account in your decision-making investment treaties. And to take into account, you need to have awareness and you need to have knowledge, and you need to create that awareness and knowledge, and that's capacity. So then the question is, where do you get the financing and the human resources to create that capacity, and also consistent capacity over time, right? This institutional capacity. So I do think it's quite interlinked. I mean, as we all know, there are different capacity building programs by international donors. That's one avenue that you have. I mean, international organizations that I think the first level would really try to be to increase kind of knowledge within the central entities that are monitoring decision making.
Right. The other thing I think that comes out is that maybe you don't need to throw resources that you don't have, but you could make the bureaucracy that matters more stable by making sure that they stay in office a longer period of time, which may or may not be difficult depending on your political system. But let me turn to some of the questions. So Catherine Wilhelm, our executive director here at USALI, has a question which I think goes in somewhat two directions. One is, who enters into this treaty versus the rest of the government? Is this in part a problem that the trade ministers are more interested in these treaties than the rest of the government, so that there could be a lack of unity here? The other issue raises is how much of this is a problem that you're pointing to, lack of internalization, because of the idea that these treaties are meant to be symbolic or performative, instead of actually considering from it in advance the need for implementation. In other words, the lack of vision of what these are for. And it is possible, given the history of these treaties, that many governments have not really realized until a claim is brought against them what they signed up to. And that may be a question of lack of information, but I wonder if you want to say more about her question.
Yeah, I mean, I think one thing we did see, and this sort of goes back to that point about parliamentary involvement, is the fragmentation of decision making with respect to entering into the investment treaty commitment, and what happens afterward. And so in a lot of countries, I think what we saw was that there was a lack of efficiency in terms of communicating across government about the commitments that are being entered into. And one thing we hypothesized was that, well, if you involved more agencies, you involved the legislative branch, for example, this in a way is almost a cheap way of diffusing information, because suddenly there are people in different ministries and in different branches of government who are aware of these treaties that may not have been aware of them otherwise. And so I think that's certainly something we observed, and it's a coordination issue really within government. Yeah, one agency may be the negotiator, the other agency may be tasked with promoting investment or facilitating investment within the country. Another agency may be tasked with representing the state or defending the state in the event of a claim, but they may not all be involved or talking to one another. And again, it just comes back to that point. This doesn't just happen. States need to make decisions and make commitments to establish structures to make it happen, which isn't to say that it's easy to do that, but just that I think states have not always been aware, and perhaps that goes to the other point, of the risks and the commitments that they're undertaking and what's really involved there. Ayelet, did you add?
Yeah, you want to add anything to that? So one of the questions in the Q&A box does follow up on this, and I think you've answered it. When is it important for other parts of the government not directly involved in the adoption of the treaty to internalize its terms? And I guess that's part of the information that all too often only the negotiators of the treaty are the ones directly involved in thinking about internalization. So I don't know if you want to add anything in response to that question.
I mean, it's not necessarily only the negotiators, but there may indeed be specialized nodes within government that have this information. And in the work that I've done, I've yet to encounter a government that did not have some node of expertise and knowledge. But the question is whether or not that knowledge is connected to other decision-making actors within government. and then whether or not it has any particular sway or any formal means of being heard. So I think that's the real challenge that states face, is actually bringing that into account. And it's a capacity issue and a governance issue, I think, as much as an investment treaty specific issue.
So one of the things that your book brings out is that exposure to investor state claims doesn't always work in the deterrence way that some people had envisioned. Sometimes it actually inspires backlash, either withdrawing from the treaty, changing the terms to make it easier to comply, and perhaps worse on the foreign investor. When is that likely to happen? Is it the fault of the actual investor state process, that it has exorbitant amount of money, or surprising results, as some people would say about white industries? Can you say more about this backlash produced by investor claims as part of your thesis?
You want to take that, Ayelet?
I think the backlash is mostly political, more than bureaucratic. I mean, that's what really comes out. It really depends if there is it's mostly political. Is there kind of rejection, backlash, political at the parliament level or at the public level to the investment treaties? I think that's where it mostly comes from. That's what I take away from our case studies. I don't know if you have any other ideas on that, Jansen.
I guess, it's observable that in those situations, the political salience of the issue is heightened often by nationalist or populist themes. And it plays into perhaps a greater or more prevalent political narrative that the state is under attack. We didn't, in our study, I mean, this is speculation, we didn't examine particularly what was happening in those individual countries and attempt to draw conclusions across those situations. I mean, the countries in which this has really been seen are a pretty diverse group, whether it's Indonesia, India, South Africa, Ecuador, Venezuela. I mean, so that's a different study, I think, in a way. But clearly, it's the heightened political salience, and it may be some element of populism that frames the issue.
Which, of course, is quite prevalent around the world. So populism doesn't necessarily work to the benefit of investor claims as deterrence. Now, from Franco Ferrari here at NYU, he wonders if we can draw anything from the lack of participation in the investment treaty regime. And he's thinking in particular of, say, Brazil, which has not ratified at least traditional investment agreements, and yet, of course, attracts investment. Is there anything you want to say about the dog that doesn't bark? That is, the treaties that don't exist among this group of nations, or the pairs of treaties that don't exist? And of course, one salient one is, of course, there is no US-China bilateral investment treaty, right? Does that tell us something about the actual force of these treaties? The fact that you don't have some pairs of investment treaties might suggest that they're taken somewhat seriously, but then there's Franco's question that, some countries, maybe it's a rare exception, but I'm not so sure it's so rare these days, are doing quite well on both rule of law and FDI without these things.
I mean, I think the Brazilian example, which is often cited in these kinds of discussions, it highlights that there isn't a one-size-fits-all for states, and states, certainly these treaties are not a necessity for some states. Maybe they are for other states. It's again, that comes back to that question about their role in attracting FDI. Brazil is a very, very large economy. It has a very, very large population and market. So it has certain particular factors which may naturally attract FDI into the country. I can't speak to the Brazilian situation particularly, but it does seem to me, though, that it has always been interesting that among the pairs that are missing have always been the developed pairs, with the exception of Canada and the United States, tied together in the NAFTA and then in CAFTA. But there was never a U.S.-Britain bilateral investment treaty, presumably because no one thought that that was a necessity. And we've never seen those kinds of treaties. And obviously the bilateral flows of investment between those countries has been adequate, or been seen to be adequate by the policymakers there. So I don't know what to tell you. I think there certainly there's room for experimentation, and I think that that's where states are going now with investment facilitation, as you mentioned. I mean, that's the focus that Brazil has placed on its current bilateral investment treaties. And I think states which are inclined to keep with the investment protection dispute settlement model are also, though, seeing that investment facilitation, either in investment chapters and FTAs or through a multilateral instrument at the WTO, is an area that's been perhaps neglected, and is something that they can also address at the same time.
Of course, investment facilitation would actually have to be internalized as well, right? So there's always the challenge that you could put them in the treaty, but will the bureaucrats actually do what they're supposed to do, and so forth? But there's some excellent questions in the Q&A box. So here's one. You've stressed a lot the importance of information. And the questioners points out that a lot of BITs are negotiated in secret without the involvement of civil society organizations, broader legal scholars, or even academic institutions. And he's saying, wouldn't it be better to have all of those be involved from the outset? And doesn't that suggest that one way of doing better on your internalization is for states to be much more transparent about their negotiations, the process, why they're doing it, and that doesn't have anything necessarily to do with regime type. In other words, states can be selective about which ones of their treaties they are public about. But what do you say about that?
Yeah, shall I take that?
Yeah.
I think that's a very good point. And my sense is that it would improve internalization. So once you open it up actually to public consultation, to public notice and comments, I think we see that in Korea, who opened up the FTA negotiation process to comments. So yeah, you bring in the public, you bring in the media, and that of course increases awareness and salience and has an impact, I would theorize, on internalization. So I would say yes, as part of the general packaging of improving internalization, that could definitely also be one of the tools that we could introduce.
Any comment on that? Further comment on that, Professor Calamita?
No, not really, except it does go back to, again, that point that we saw where, if you have parliamentary involvement, this tends to suggest a greater political salience and greater internalization, or at least a greater likelihood that steps will be taken to attempt to improve internalization.
So there's another question from someone who I suspect has read Tom Ginsburg's article back in 2005 that basically suggested that it's not just that IAIs don't improve rule of law, they actually hurt rule of law, because you've created a disincentive to improve your domestic courts, because the powerful foreign investors who might otherwise be leaning on the improvement of rule of law have an out. They can go to investor-state dispute settlement. Now, Professor Ginsburg didn't have the data that you guys have, but I'm curious, do you see any evidence that these things actually hurt the domestic rule of law?
Not in the way that Professor Ginsburg had suggested. I think it's, first of all, we didn't see any evidence that states were either diverting resources or otherwise not putting resources into improving the domestic institutions or domestic rule of law because of the existence of these international fora of international arbitration and so forth. And I think the data on investor attitudes in any event is that investors very much would rather use domestic institutions, courts, and other mechanisms than go to ISDS. So there's no real lack of incentive, I think, created by the existence of this mechanism. States continue to have incentives to create a legal environment in which investors want to invest, and that's the whole investment facilitation angle. The existence of this has its own drawbacks and its own issues, but I don't think it goes in that direction, or at least that's not what the evidence we found in this study suggests.
So there's another question, unless Professor Berman, did you want to say anything on that?
Yeah, I just wanted to add on that. I mean, again, his focus is on courts. I think most of our focus has been on the administrative decision making, which is in a way, it's a different question. So, how does it improve decision making? And there we haven't seen, adverse effects. I will say just one thing on the courts, because I think what he says, I haven't read that article in a long time, that it really kind of reduces the role of courts. We do have one example of that in India, where we see that following the White Industries case, they did amend the name of the law is the Arbitration and Conciliation Law, which essentially reduced the involvement of courts in arbitration procedures in the country in general. And then, the question is that an adverse or a good impact on rule of law? Because on the one hand, of course, you reduce the involvement of the courts, but on the other hand, we know why they were reduced, because it delayed the processes to such an extent that we can't really talk about.
Yes, that it became an arguable violation of fair and equitable treatment, as I recall, right? Or the equivalent, because it took 15 years or something, right?
So, yeah.
So there's a great question about the investment reform process, which is focused on rebalancing the duties and rights of investors versus the rights of states to regulate. And the questioner says, why do you want to pile on more responsibilities on host states, given many of their capacity restraints? And he suggests that both home and investors, both the home states and foreign investors, reject having binding obligations. And therefore, what should be the role of home states of foreign investors in the internalization process? Should we consider binding obligations on home states, on foreign investors? I'll leave it to you. And I know this takes you quite out of the comfort zone of your book, but I do think it's an interesting question, since this is the heart of many people's view of the reform agenda.
I think that's a very legitimate, oh, sorry, go ahead, Jansen.
I was just going to say, I don't think what we're talking about here is about piling further obligations on states through internalization. I mean, these are commitments that states have undertaken, and it's really now, the commitments are there. It's in the state's interest to figure out how to manage those commitments as best as possible. And to do that, I think, implicates internalization and taking the kind of measures to internalize these commitments that we've been talking about. On the other side, though, what about home states? Home states are not obligated to do a great deal under most investment treaties. The program that I was describing under the ASEAN, Australia, New Zealand FTA, whereby Australia and New Zealand are essentially funding a work program to help developing members of ASEAN with respect to their commitments, that I think is a promising type of initiative, and one that I would hope to see emulated in other treaties. But it's really on the investment facilitation side, to go back to the WTO negotiations that you were mentioning earlier on. I mean, states already have a great deal of incentive to create a legal environment that attracts investment. States seek investment. And so in a sense, they are incentivized to adopt measures that will help to facilitate investment. At the WTO now, though, we're looking to move from just being incentivized to being legally obligated, to creating international obligations to meet certain disciplines with respect to investment facilitation. That does raise the question of, well, are you not just potentially putting more obligations now on states, particularly developing states, which are already struggling to implement and internalize the obligations they already have? So if so, then where's the quid for the quo for the developing states? Will you provide the kind of support through technical assistance and so forth that these states likely need? And I think and then I'll stop to give to Ayelet a chance, but the discussion in the working group 3 of UNCITRAL right now about establishing an advisory center on international investment law is quite promising, to the extent that it addresses what is clearly a need for many developing states, and that is how to manage your investment treaty commitments, before you get sued.
Mhm.
Certainly you need help once you get sued, but to avoid the claim altogether, that's the gold standard.
Professor Berman, do you want to comment on this before I go to another question?
I think I actually want to really say things that Jansen has mentioned. I mean, in the end, if we could really think of a structure whereby these investment treaties also include some kind of capacity building support, very much like we see in trade agreements, because for the moment, essentially, home states receive all these obligations, and we see that they don't really have the capacity to internalize them. So any kind of technical capacity support is something, that we could definitely think of.
So here's a question. You described, I think, Professor Calamita, the way you ended up writing about or selecting your 8 case studies as a product of where you're located. You focus on Asia and doing that. Your book also stresses quite a bit the big differences among those 8 countries. But one of the questioners is asking, is there any tendency, commonality that you see? Is there anything about an Asian attitude towards investment treaties, towards international law? Is there an Asian school of international law or of investment law that you see emerging from anything you've looked at?
That sounds like a different book. I mean, it's a great question, and I'm not sure how one would necessarily go about studying it, but we didn't in our book see things that I think we would have described as particularly Asian, and we weren't really looking in that direction either. I mean, the countries that we were looking at are so vastly diverse, from North Asia to Southeast Asia to South Asia, developed, developing, liberal, illiberal, Islamic, not Islamic, I mean, the whole gamut. So to discern something within all that as Asian, we didn't see anything.
There was the factor, of course, that both of you have mentioned of a political approach to whether they're going to comply with international law. And the way that's phrased, at least on your PowerPoint, is a general commitment to international law. I guess I was a bit surprised by that, because some people would say that countries may be very broadly committed to international law, but not to the consequences of these treaties. But I think you're suggesting that there's some commonalities between your general commitment to international law and pacta sunt servanda and international order, and their commitment to these treaties. You want to say anything about that?
I mean, I guess what we observed, and we're probably referring to, we were principally thinking about Vietnam and Singapore, is that there was a policy decision effectively to ensure that the state was integrated into the international legal order, and in its international commitments would be internalized in the domestic legal order, specifically to create an environment for the economy to grow, to attract international investment. And so I think, it's not to say that other states don't have that in mind, but this seemed to have been a sort of policy level commitment beyond simply the legal acceptance of pacta sunt servanda.
So one question comes, and I do think does follow more closely some of the material you're discussing. And this is, I'll just read it. China has a large number of investment treaties, has been revising, updating its domestic law on foreign investment since at least 2019. Yet China has continued to sign investment treaties over a long period of time. And there's changes in domestic law and regulations have occurred since some of those treaties have been concluded. How to understand and examine the internalization of these treaties over time. That is, don't states have to continuously then revise their laws, practices, even as later treaties emerge, as treaties become different? What do you say about that problem?
Again, look, because the focus was on internalization, which is essentially the question, do they take investment treaties into account? So no, the answer is not beyond what the government would normally evolve, because, you know, of course, the investment treaties themselves can change over time, but the governance framework should actually be quite robust and persistent over time.
I mean, investment treaties are a way of life, right? In that sense, it's not just a one-off commitment, but you have to live with them. And that means, you know, as your domestic laws change and evolve, you know, they should be evolving with your international obligations in mind. And perhaps your international obligations should be evolving as they may no longer seem fit for purpose vis-a-vis what you want to do as a regulatory matter.
Right, and I guess I want to raise a challenge that's broader than just internalizing the treaties. I've spoken to folks in the US State Department that say one challenge, even for a country like the US, which has an awful lot of lawyers, is keeping track of the jurisprudence, so that who has the resources to keep track of the evolving definition of fair and equitable treatment, to say, no, that's wrong and this is right. In that, internalizing the jurisprudence of hundreds of awards, many of which have nothing to do with your country, is a huge challenge. How does a poorer country especially internalize that?
Yeah, I mean, I guess, you know, so one of the upshots of this study, or one, you know, a companion piece to this study, was work that we did on a policy level with APEC to create a handbook for non-lawyer government officials in government that would provide them with an overview of the essential concepts of investment treaty commitments and how they can apply to the day-to-day business of government. So on that level, which is really the informational internalization level, where you're not speaking to lawyers, because most often the decisions are not being made by lawyers, the level of diffusion and familiarity doesn't need to get into that level of detail that you're describing, the nuances of the jurisprudence with regard to legitimate expectations. That's not needed in order to diffuse the information across bureaucracy. What those folks need to know, in my opinion, is they need to have an awareness that there are issues out there, a general understanding of where those issues can arise, and they need to know who to call when they have a question. Now that then consolidates the node of expertise, because you have, you know, if the people are just reaching out to the specialist, then it's a much smaller group. Still, keeping on track, on top of the jurisprudence, and I would argue even perhaps more interestingly on the evolution of treaty drafting practice, is difficult for even dedicated specialists. That's again where international capacity building support can come in. I mean, UNCTAD does great work in this space, IASD, both, you know, so NGOs and IOs, that states need to rely upon that. And I think states, to be honest, sometimes don't necessarily take full advantage of all of the resources that may be available to them.
So we're running close on time, but there are a couple.
I'd just like to add,
Yes, Yes.
Just, I think that's where the idea, which has been kind of raised, of an advisory center on investment law comes in, because not even the richest country in the world, as you say, has the capacity to really follow everything that's going on. So we need to start thinking about centralizing this information, as we have also in the case of the WTO law, institutionalizing this more.
So there's a question about the validity, or whether entry into force of the RCEP could help with respect to internalization. And maybe that's too specific a question, but I think I'm curious if you see that a country's accumulation of treaties makes any difference. The more they have, perhaps there's a more uptick in information or internalization. But you also raise in your book that some treaties between some pairs of countries, in particular pairing with the US, seems to matter more. Can you say something about those questions?
At political salience, I think, again, there appears to be something about negotiating with the United States in particular that raises the political salience of the negotiation and the treaty. Obviously, we saw that in Korea, particularly with Chorus, and we've seen it outside of Asia, just anecdotally, with the TTIP, as it was called, the Transatlantic Investment Trade Partnership. So I think it goes back to that issue of, does the pairing have a particular political salience? With respect to RCEP, I don't know if that's the case at all. And at the moment, RCEP doesn't have investor state dispute settlement. So there may be, that tamps down on the salience.
And what about the pileup of treaties? Any evidence that the more investment agreements a state has, the more likely, or is it less likely they'll internalize?
I don't think we saw that. I think what we did see is that getting sued
that matters.
has a way of focusing the mind. But even there's no guarantee that actual change will occur, that
Right.
effective change will occur.
Or in fact, it creates backlash. There's one last question I can't resist, because it takes me back to the old days of negotiating these things. What if I'm negotiating one of these treaties? I'm pretty sure that my negotiating counterparts are not going to get buy-in from the whole government. From my point of view, are there still good reasons to go ahead with negotiating a treaty, even if I know that the effect is questionable? There is no prospect of internalization, or little prospect. Should I go ahead and bother?
Yes, worst case, you sue them if it doesn't work out.
Oh, wow. Okay. So this is just a buy-in for more investment treaties. Now, of course, if you're a cynic about this, it would say it's because some of the folks involved in this are also arbitrators, and they like to maintain the system going forward. And I can think of several people, including at your home school, that might make that argument. But this has been a delight. I don't know if either of you want to have, was 1 minute for closing statement of something that didn't come out that we should have asked.
Nothing that we should have asked, but just many thanks for having us and the opportunity to talk about the book.
This is great. I look forward to the cheap paperback version sold at airports everywhere. Thank you both, and thank you for the audience for these great questions. Take care.
Bye-bye.